Before we begin this afternoon, I want to, on behalf of the court, thank counsel on both sides for their interest and willingness to participate in oral argument in person today during these admittedly challenging times. With that, we will call our sole case for the afternoon, 20-10652, Priest versus Grazier. Let's see, Mr. Illich, did I pronounce that correctly? We will hear from you first.
May it please the court. My name is Niles, Illich, and I, along with my co-counsel, James Roberts, represent the appellate, John Priest. I've reserved 5 minutes for Mr. Roberts' rebuttal. As a preliminary matter, as Judge Ho started, I'd like to thank the court for having us here live today and for all the accommodations over the past year. We want to discuss 2 issues with the court this afternoon, but in the end, we expect that the court is going to see this as the ordinary summary judgment case that it is. This is a routine summary judgment case because here, the magistrate misapplied the summary judgment standard by discrediting the evidence that favored the non-movement. First, we will show that under the right standard, that the evidence clearly established that the use of force was objectively unreasonable. Second, we will show that under the right standard, the law was clearly established. Turning to the argument that Appellee's use of force was objectively unreasonable, the magistrate's findings all turn on the conclusion that appellant was resisting. The magistrate reached this conclusion by disregarding the evidence that favored appellant. There is evidence on both sides of this case, and had the magistrate applied the summary judgment standards correctly, then the magistrate would have analyzed the case under the following 8 facts. And I'm going to ask the court's indulgence as I go through them. It just takes me a moment, but I really do think they're important. The first fact is that the video establishes that the police were out of their car for about 2 minutes trying to get appellant to open the locked car, and they didn't use guns or tasers to do that. And appellant never tried to flee in the car. Second, the police decided that they had to break into the car because, in their words, appellant wouldn't talk to them, and you can find that at ROA 706. Third, appellees didn't feel the need to use deadly force or a baton, and the video shows that they didn't use a taser. You can find that at ROA 761 and 762. Fourth, the appellees entered the car to release appellant without appellant acting violently and without any weapons drawn. You can see that clearly in the video. Fifth, the police knew that the glass was on the ground and that the shattered glass was dangerous. That's at Record on Appeal 707 through 708, 766, and 767. Sixth, that the appellees intended to put appellant into the broken glass and they were trained not to injure suspects with broken glass. You can find that at ROA 713, 766, and 767. Seventh, that appellant did not kick, punch, strike, or attempt to flee. You can find that at ROA 714 and 769. And last, appellees, in their own words, pinned appellant's face down to the ground with his right arm pinned under him with the combined weight of 2 police officers, which approximated 550 pounds. These are the facts that should have governed the resolution of the case, and they would have had the magistrate applied the summary judgment standard correctly. Fundamentally, however, the magistrate's opinion is predicated on weighing the evidence and concluding that appellant was resisting. Importantly, when we consider this evidence, the law that governs the use of force and the application of the proper summary judgment standard, I think it's evident that the magistrate reached the wrong conclusion and that the use of force was objectively unreasonable. And we know from DeVille and related cases from this court that a police officer must assess not only the need for force, but also the relationship between the need and the amount of force used. As this court held in DeVille, taking the facts in the light most favorable to the plaintiff, a jury could reasonably find that the degree of force the officers used was not justifiable under the circumstances. This court looks to the timing, amount, and form of a suspect's resistance to determine whether the force used was appropriate or excessive. And here...
Counsel, where do you think the force became excessive?
I'm sorry, Judge Oldham, I couldn't hear you.
I said, where do you think the force became excessive? Were they okay to break the window and to try to remove your client from the car?
Yes, Judge Oldham, and thank you for that question. I think it's really an important question here. They were absolutely within their right to break the window. I think they were patient in trying to resolve it. They had a situation where this guy's in the middle of the road. He's not responding to him. They had every right, in my mind, to break the window, even to get him out of the car. I think the problem comes, and we have to remember, I think, that they have to continue to measure their use of force. It's not just what it is at the beginning, but what it is at the moment. The problem comes, and I'm getting to the answer to your question, Judge Oldham, is that when they get him out of the car, they know the glass is on the ground. They know that they're putting him in the glass, and then they put their weight on him and press his face into that glass. And the video, I think you've seen probably better videos than this one. It's not as clear as a lot, but you will see that one knee only is on the lower head, upper neck of the defendant, pressing his face into glass. And so the simple answer to your question, Judge Oldham, is that I think the force became excessive when they put him onto the glass and pressed his face into the glass.
And what would be the evidence that they intentionally put his face into the glass?
Sure. And I think we can look to some of the factors that I cited to you in the beginning. And when we go to the deposition testimony of the two appellees, we see that they say, we know the glass was on the ground. I think it's on page 767 of the record. We know that we put him in the glass. We know that the glass is dangerous, and we did it anyway. And not only did they do it anyway, maybe that even would be okay, but when they press his face into that glass, I think we really take a step further. That factors have changed. They've gone from the regular use of force to the excessive use of force.
Counsel, but for the glass on the ground, was there anything wrong in your view with what they did as far as getting him down and subduing him so they handcuffed him? In other words, if you take the glass off the asphalt, is everything else okay? By everything else, let's focus on the initial removing him from the car and getting him on the ground.
Okay. Yes, then Judge Wilson, yes. The answer is if they'd taken him out of the car and they'd put him down and there hadn't been glass there and they'd put pressure even on the back of his head and his neck, I don't think we would be here today. I think that would be an allowable, perhaps, use of force, but that's, of course, not what we have here.
Are there any cases that come from our court or others that involve, say, accidentally putting someone in glass or even intentionally? In other words, what's your best case for excessive force in terms of subduing him to the point that they're handcuffing that first arm?
Well, and Judge Oldham or Judge Wilson, I'm having just a little bit of trouble hearing you. So if I didn't get this answer, if I don't address everything, please let me know. But I think that there are a couple of issues here. The first is that there is no case that's directly on point with this. I think the closest case that we have is a 12b-6, and I think you'll see a reference to that in footnote 16 of the opinion. But it is, of course, a 12b-6 case, and it's a case without glass, but they're pressing I think it's Alexander versus Round Rock. They're pressing the man's head and face into the ground. And they found that as it was pled, now of course it's 12b-6, but as it was pled, they got around qualified immunity. But I think the best case that we have is we have to go and talk about this being really a novel application of force. This has got to be a Newman-type case where we know that there is a constitutional rule against hitting, kicking, slamming a person who is not resisting. That constitutes excessive force, and Newman says that the novel use of force, in other words, a method of force that hadn't been used before, will not protect somebody from, will not get you to qualified immunity.
What is your evidence of non-resistance? I mean, I take you're acknowledging that if there is resistance, then you probably don't have a case here, right? You're premised on non-resistance.
Yes, Judge Ho.
I see plenty of evidence of resistance. What is your evidence of non-resistance?
Okay, I think there are a couple of things. I think the first thing we would have to do is to remember the standard that we're working under. And of course, the court's intimately familiar with that standard. But that means that not only the testimony, but inferences go in our favor.
Sure.
And when we look at the video, I think you can see from the video when they pull him out of the car, at least in the summary judgment context, there's no resistance. Further, we have the deposition testimony from the appellees who say there's no kicking, there's no hitting, there's no punching, there's nothing of that sort. This is a man who, for whatever reason, and of course it doesn't matter that he's in medical distress because the police didn't know that, but for whatever reason.
Well, the testimony I see is that he's actively, I'm just quoting, actively preventing us from securing him in handcuffs.
I'm sorry?
Actively preventing us from securing him in handcuffs. And
Yeah.
we know from the Griggs case that police officers, at least under our precedents, can use force if somebody is resisting arrest.
Yes.
Resisting handcuffs.
Yes, Judge Ho, of course. And I think you can look to the record on appeal at page 715, 716, 717, and 771. I'm kind of going off my head here. But what that says is that the police had pinned his arm underneath his body with two police officers on top of him with a combined weight of about 550 pounds.
You're talking about the Grazier testimony?
I don't remember. I think it was Grazier. I don't remember whose affidavit testimony, whose deposition testimony that was. But you see it in the video as well, that both of these officers.
Well, but I've seen the video. I agree with what you said earlier, that the video was just not terribly helpful one way or the other. It's grainy. And I think everybody's sort of, your vision is blocked.
Yes.
During the time period you're talking about. So I assume you're focusing on the testimony. I see Fenwick saying he's actively preventing us from securing him in handcuffs. And so I take it your theory is that Grazier's somehow contradicting Fenwick. But I see Grazier saying the same thing, that his arms are moving around.
Well, I do not have the testimony right in front of me. I have in my mind 715, 716, 717, 771 talking about pinning his arm under his body. And I think you can see from the video, even though it is largely deficient and not what we would like it to be, you can see two police officers on top of this man.
But I don't understand how that helps you. It strikes me that it takes two officers to restrain him. And you can tell, I agree the video is not terribly helpful, but you can definitely see there's a struggle and they cannot get his hands into the handcuffs. And I do have the deposition testimony in front of me. And Fenwick says, the question presented at the deposition is, so when you put Mr. Priest on the ground, did you have full control of him at that time? No. Okay, so when you got on top of Mr. Priest, did you have full control of him at that time? No. Even though you and Corporal Grazier were holding him to the ground, correct? Correct. So they clearly, the deposition testimony makes it sound like the officers clearly didn't have control of him. The video, at best, is inconclusive, so I'm not sure what to do about it.
Sure, Judge Oldham, if I may, I think there are two things there. Number one, this is summary judgment, so we have to look at things from the light most favorable to the non-movement. In other words, my client. You have the deposition testimony right there, but I am absolutely 100% confident that, and I may have cited the wrong page, but they say he had his arm pinned underneath him. And so if his arm is pinned underneath him and he's unable to move that arm, then it isn't resistance. Not giving up that arm isn't resistance. It's just a physical incapability. And then, of course, come the punches and they change and then he's able to surrender the hand. But I think this comes down to what really this case is about, and that is about summary judgment. And that this is a fact issue that really belongs with the jury, not with the magistrate in this case. And so I do understand and appreciate your question. I just think it can go both ways on that, Judge Oldham. And when we get to something that does go both ways like that, I think that says summary judgment is the wrong remedy.
So just to be clear, it's coming from a question from the deposing attorney, and it's, so his right arm was underneath him as he was pinned to the ground by Officer Fenwick and yourself. So it sounds like, and the answer from Grazier is yes. It sounds like what's going on is his arm, the body is pinned to the ground. I'm not sure what to make of the right arm.
The deposition testimony will show, and I really thought it was 7:15, 16, 17.
I have 410 for what it's worth.
And 71,
410.
but the deposition testimony uses the word pinned to the ground, that his
Absolutely.
arm was pinned to the ground and his arm is underneath it. And that's really what we are going with to show that this was not resistance in that
So is
respect.
your theory that Grazier and Fenwick are offering inconsistent testimony? Because Fenwick is saying that he's actively preventing us from securing him in handcuffs.
Sure, and Judge Ho, I see I'm about to run out of time,
Go ahead.
but if I may finish. I think the depositions are internally inconsistent between, even within one particular appellee. You can find things that support us, and you can find things that go against us. And because of that, I think summary judgment was improper. And I've run out of time, but if there are no further questions.
If I may ask one more question, I don't think there's any dispute that, as it turns out, this was a medical situation. He was having a
That's
medical
correct,
episode,
Judge Ho.
in distress. I'm just curious, I don't mean to speak outside of my area of expertise, but was he wearing any sort of bracelet or any indication?
I don't think he was.
Is that something that, pardon my ignorance, and you may not be aware either, but is that something that diabetics who have certain vulnerabilities might display? Because from the officer's standpoint, it's tragic that they didn't know it was a medical episode, but they didn't know it was a medical episode. It was during this, admittedly potentially suspicious situation. How are they supposed to know? Because I'm trying to protect people, but I'm also trying to understand that officers have a hard job to do.
Well, they do have a hard job to do, but I think there are two parts to that question. I want to answer them both. The first is, do diabetics typically wear that? I don't know. I'm an epileptic. I don't wear a belt. I don't wear a bracelet on my wrist that says I'm an epileptic. So I could end up in a situation like this. But I think, number one, you have the police that are outside of the car for 2 minutes watching him. So they have some context of what's going on. They don't know exactly what it is. It could be that he's intoxicated. It could be that he's having a medical issue. But I think these are the sorts of issues police officers are trained to deal with and trained to recognize, where you, or certainly me, wouldn't necessarily know what to do. So I hope that answers your question, Judge Ho. I thank the court for having us. It's a pleasure to be back in front of the court in person, and thank you for the accommodations over the past year.
Thank you. Your colleague is reserved 5 minutes. Ms. James, we'll hear from you.
May it please the court. My name is Stephanie James, and I represent Appellee Officer Logan Grazier. I'm also presenting argument on behalf of Appellee Officer Michael Fenwick, though his attorney is here present in the courtroom today. Despite the appellant's assertions of error with the order of the district court and the opinion of the magistrate judge, the undisputed summary judgment evidence in this case established that the officers were entitled to qualified immunity. I would like
Well, they have this theory that the two depositions are inconsistent, and so there is a dispute as between Grazier and Fenwick. Can you speak to that?
Certainly, Your Honor. Two points on that. First, the deposition testimony that they cite to is the section that you read, where the attorney is cross-examining Grazier and used the word pin, and pin response yes. That portion of the deposition testimony was taken after he had shown Grazier the video. So my first point being that Grazier had the benefit of 20/20 hindsight when he responded to that question during the deposition. My second point is that I don't think the two depositions are truly conflicting. That is a small portion of Grazier's testimony, but he also goes on to testify in other places, as I believe you noted, that he witnessed Priest still reaching toward his pockets while on the ground, and that he was thrashing around and out of control. You also mentioned the testimony from Fenwick, which is a direct quote. He was not cooperating, he was resisting, he was pulling his hands away from us.
But what do you make of, I grant you that the testimony is substantial in that regard, but at the end of the day, Grazier agrees that Priest's right arm was, quote, underneath him as he was pinned to the ground by Officer Fenwick and Grazier. And then it goes on, he's pinned underneath the body weight of Priest, the hands, the right arm is, quote, pinned underneath the body weight of Priest, Grazier, and Fenwick. All three people covering up that. That sounds like a fact pattern of not resistance, but his right arm is trapped.
Well, Your Honor, actually, I think that this court has dealt with a very similar fact pattern and held there was resistance. In Griggs versus Brewer, which was a 2016 case from this court, which we cited in our brief, in that case, the officers took a suspect to the ground and 2 officers placed their weight on top of him. They tried to cuff him and couldn't because his hands both were under his stomach. So the officers punched him, were able to control his hands and cuff him. And in that case, this court held he was resisting and that the officer's actions were reasonable.
Okay, but there was, I have not looked at the underlying record of Griggs, but I've read the opinion. Griggs, the court finds resistance, whereas here we're trying to figure out whether there was resistance or not.
Right, and my position is those facts were similar in that in Griggs too, they were 2 officers laying on him, his hands were under his stomach, and they still found he resisted. Another important fact is in that case, at that point in the encounter in Griggs, they had already searched him. In this case, recall that Priest had not been searched.
But in Griggs, I see language about how the person tucked his arms back under him after resisting, so...
Yeah, there was multiple punches. So
right, and then he puts his arms back under, which suggests strongly resistance. Whereas here, it sounds like his arms may have been pinned due to what the officers were doing. That's what it sounds like Grazier is saying.
Your Honor, I think again that Grazier responded to that question in the deposition after being shown the video with the benefit of hindsight. The inquiry for this court is not what actually happened or what the historical facts were, but what a reasonable officer at the scene on that time would have perceived.
Is your point that he did not know at the time that the arm was pinned, but now that he sees the video,
perhaps he realized he was
oh
wrong?
my goodness, he wasn't resisting. I thought he was resisting, but as it turns out, he wasn't.
Correct, yes. And the point being that the other testimony from the officers is that, and this is shown on the video, you can see him kicking his legs and thrashing around, that he's still reaching toward his pockets, and that they believed he was out of control and might have had a weapon. The other important thing I wanted to address, which I don't believe was...
Before you turn away,
Sure.
What do you make of the fact, I think Counsel and I agree, that the video is really not that easy to see, particularly at this moment in the episode. But you're saying that Grazier saw the video and all of a sudden came to this epiphany that in fact there was no resistance?
I think portions of the video are clear and portions are not. I think the removal of the car is clear. I think you can tell their weight is on him from the video, which is what Grazier was asked about. I don't think you can tell specifically what was going on under his body from the video because the video obscures
So then why would the video all of a sudden inform Grazier that as it turns out, he was not resisting?
Well, I think that the fact that they were putting their weight on him is clearly shown on the video. That's one of the things he could have clearly seen from the video, whereas these other issues we're addressing are not. And I think on the topic of the video, which you questioned him about, what do we do where that's unclear, and does that create a fact issue? I think it doesn't. I think the fact that something is unclear and could go one way or the other, as he said, means that the court has to look to other pieces of evidence.
Okay, but as I understand what you're saying today, I think your position is, as it turns out, Mr. Priest was not resisting.
Perhaps.
Based on hindsight.
Perhaps,
admittedly.
yes.
But at the time, the officers didn't know that. It's a fast-moving event. Believe me, I can appreciate that. We can assume that they're doing the best that they can, perhaps. They did not know at the time that he was actually not trying to resist.
Or that his resistance or moving around was caused by this diabetic episode they were unaware that he was experiencing.
Well, but counsel, that the officers don't testify that, well, in hindsight, I now see he wasn't resisting, but at the time I thought he was resisting. They don't say that in their testimony, do they?
They don't, but the question that he cites too about you can see his hand is pinned under his body is also not asked from the perspective of were you aware of that at the time. All of the testimony from the officers about what were you aware of at the time, what did you perceive at the time, was that he was actively resisting. Even later in the encounter, so there were the hand strikes and then the subsequent knee strike from Grazier. Later in the encounter, in that same deposition, opposing counsel asked Grazier about the knee strike. And the direct question is, so is it your position you administered the knee strike because he was resisting? And Grazier responds, yes, sir.
Well, but so we've got, to break this down a little bit, we've got the initial removal from the car, and he's put on the ground, and they're attempting to handcuff him. So that's sort of episode one.
Yes.
Episode 2 are, I think there are 3 punches that are administered, and that's the point in the video where the officers are actually blocking what's going on. But we know that he's got one arm pinned under him by the fact that their weight is on top of him, but yet these 3 punches, you can sort of see them in the video, but that's episode 2.
Correct.
But then episode 3 is the one you were just talking about, where the knee is delivered, even though he's handcuffed. But at that point in the video, you can actually see him moving around, kicking and screaming. You can hear him doing those things. So I guess my question is, can we have a situation where there's no fact issue with regard to episode 1, there's no fact issue in terms of summary judgment for this purpose on episode 3, but because of the combination of the lack of clarity in the video and the lack of clarity in the deposition testimony, there is a fact issue with regard to that second episode, the punches?
I think the court could result in that finding if it felt that was the correct result, because you do examine it on a use of force by use of force basis as the encounter goes on. My response to that, though, would be is that this is a 2-part analysis. Objective reasonableness, and then whether their actions violated clearly established right. So even if, you were thinking, all right, that second use of force, those hand strikes, I think there may have been a fact issue there. Appellant still had the burden of proof to be able to cite to a case some clearly established law that shows that the officers should have been on notice that their actions violated the law, and he has not done so.
You don't think it's, I want to make sure I understand what is and is not clearly established. You don't think it's clearly established that if somebody's not resisting, the officer should not punch him?
I think that rule of law is absolutely clearly established, but I think it is much too general. This court has long recognized that the question of whether a right is clearly established is one that requires a high degree of specificity, particularly in these excessive force cases, and has said the rule of law that if you're no longer resisting, you can't use force is too broad, has said the rule of law that you can't unreasonably or unlawfully seize someone is too broad. Though it does not have to be an identical fact pattern, the language from this court says it has to be substantially similar and has to squarely govern the facts
So
of
we
this
know
case.
that you can't unreasonably search and seize is
Sure.
way too general. We know that citing Tennessee versus Garner is way too general. What level of specificity do you want? Because you did acknowledge, I think, that if somebody's not resisting, you can't punch them. What more? Okay, but if that rule is too general, what more facts do you need in a particular holding to be specific enough?
Well, by way of example, the line of cases they've cited for that proposition are the Darden case, the Newman case, the Bush case. Those cases involved situations where the suspect was not behaving erratically, able to communicate with police officers, and ceased resisting and complied with commands. In the main case they rely on, Darden, they entered the suspect's house and he immediately put his hands up in the air. Then, once they were on top of him, he started kind of moving around, having some problems, and yelled, "I have asthma, I can't breathe." And everyone else in the house said, "He has asthma, he can't breathe." That's the main case they rely on. That does not tell these officers what you should do in a situation where you encounter a suspect who is erratic, non-compliant, unwilling or able to talk to you, flailing around like crazy. What do you do in that situation? They have not cited to that precedent, but we have. In both our briefing to the trial court and to this court, we have cited to 2 cases, albeit not from this circuit, that are quite factually similar, from the 6th and 8th Circuit. Now, those aren't binding on this court, but I think they are instructive as to the analysis. In those cases, the first one, Wordish versus Kruger, out of the 8th Circuit, you have the police officers who receive a report of an erratic driver. Turns out the driver was driving home from work and experienced a diabetic episode. He has no real memory of the encounter. They try to pull him over and he will not exit the car, so they use force to remove him. Once on the ground, they try to cuff him. He lays on his hands, so they use force to get to his hands. Then they try to stand him up. He resists again and they use force. In that case, the 8th Circuit held he resisted and his actions were reasonable. In Wysong, the 6th Circuit case, in that case, a gentleman was acting unruly in the grocery store parking lot. Him, too, turns out, experiencing a diabetic episode, has no memory of the event. The officers confronted him and he tried to run, so they hit him and take him to the ground. He struggles with them on the ground, thrashing, kicking, and screaming. And so the officers place their weight on him. His hands are under his body, so they administer hand strikes and a knee strike to be able to cuff him. That case, too, the court held he was resisting, his actions were unreasonable. And their quote is, their actions were reasonable, even if his resistance arose from involuntary muscle spasms brought on by diabetes. So those two cases, we have a suspect who is erratic, non-compliant, unwilling to communicate with officers, will not comply with commands to exit the car. They take him to the ground, they lay on them, hands are under the body, they use force to get to their hands. Both quite factually similar to this case, and both establish that the officer's actions were reasonable. So not only has Priest failed to cite to a case which squarely governs these facts that shows the officer's actions were unreasonable, but we have gone so far as to cite to two that establish that their actions were reasonable.
But counsel, so isn't the bottom line, though, that if there is a fact issue as to whether there was resistance or not, then summary judgment wasn't appropriate, correct?
It's not, Your Honor, because this is a qualified immunity case where the burden does shift. So the way that this works is we plead qualified immunity. We say we are police officers acting in the course and scope of our job. The burden then shifts to the appellant to overcome that qualified immunity by defeating or by meeting both steps, both the objective reasonableness and the clearly established right. So they needed both. Even if they got there on step one, on that second altercation, that second event, they also had to establish that the officer's actions violated a clearly established right or summary judgment was proper. The one point I wanted to make, which you addressed with opposing counsel briefly on the reasonableness and the fact issue argument, is recall that Priest has no version of these events. So in their briefing here today, they've said there's differing versions. This is what we say happens. This is what they say happens. Priest has no version. He testified that he has no memory whatsoever of this altercation. You can find that testimony at about page 299 through 300 of the record. He says his last memory was over 3 hours prior to the encounter, and his next memory was waking up in the ambulance. So to the extent that they're purporting to say, and I think there's some footnotes in the brief, Priest actively argues he was not resisting. Okay, that's based on no evidence whatsoever. There is no testimony from Priest. There is no version of events. There's the video, the police report, and the 2 depositions from the officers, and that's it. Additionally, you discussed with opposing counsel a bit the argument that there was a use of force or an act that included grinding his face into the glass or placing him onto the glass, purposely putting him on the glass. And I want to address that briefly. There is no summary judgment at all that indicates that was an intentional act. The video, surprisingly, is quite clear of that portion in the encounter, and here's what the video shows. It shows Officer Fenwick try to take Priest out of the car with his head headed in this direction. His arm gets wrapped up in the seatbelt, causing him to flip around and fall to the ground. So what the video shows is that Priest's placement on the ground, turns out in the glass, was the result of, unfortunately, the seatbelt, not the intentional actions of the officer. The officer's testimony echoes this. Officer Fenwick testified, "I wasn't paying attention to where the glass was. I was watching the suspect." He was asked specifically in his deposition, and this is at ROA 462, "So you were aware at the time he was on the ground that he was against glass that could cut and injure him?" And he responded, "That wasn't in my mind, no." So this idea that they purposely placed him in the glass or pushed his face in the glass as a means or a method to control him, there is no support for that at all in the summary judgment record. Additionally, on the hand strike issue, in response to your questions, Judge Ho, about his arm being trapped, there was one fact I should have mentioned that I think is relevant on that issue, which is that after the conclusion of the third hand strike, he did in fact surrender his right arm, which we believe is the fact that indicates he could in fact move it and did so. Again, there is no countering testimony from Priest himself saying that he could not move or would not move. And Your Honor, if there's no further questions, that's all the argument I have today.
I do have a question. you may or may not know this, but do the officers get training on medical distress situations?
Your Honor, they do to some extent, and I will briefly respond to those questions that you asked him. I think to the couple of them, I think some diabetics do wear bands and tattoos and things like that. I know in one of the cases we've cited, the suspect told the officers, "My diabetic card is in my wallet." So I think there are some indicators that some people wear of that medical situation.
And Mr. Priest did not have any of
Not
those.
in this case, no. And the other point I would make on the training is that initially those types of claims were asserted by the plaintiff against the city of Amarillo and the police department in this case. Those claims were dismissed on a 12b6 motion, and plaintiff was given an opportunity to replead and did not take that opportunity. So the training type policy claims, should they have done something different? Should they have tried to evaluate him for a medical emergency? Those really, unfortunately, aren't before the court at this time.
I think I saw an allegation somewhere that as the first officer approached, there was somebody running away from the car.
Yes.
I haven't heard anybody mention that today. Is there anything?
Yeah, and the reason we haven't addressed it much today is they've conceded now here on appeal that it was reasonable for the officers to break the window and remove him. So it's kind of been our position, look, they've conceded that the facts and circumstances they encountered at the time they approached him, made their actions reasonable, met those Graham factors for the reasonableness of a use of force. But what happened was Grazier pulled up behind him and saw it was a high crime area next to sort of a known drug house. And recall he was parked sort of in the middle of those two lanes. And he saw two people run away from the car. So I think maybe initially he was thinking, was this some kind of transaction or what was going on?
This notion of people running away, I didn't see that on the video.
You can't hardly see it. If you rewatch the video at the very beginning, there's a bridge and you can sort of see the on-ramp, the side street to the bridge. You can see a person way up there in the corner of the lawn, but it's not shown very well on the video. And I think part of the reason for that is, recall his testimony that initially he drove by the car and then did a U-turn to flip around and come around him. So I think him seeing the people wasn't on the initial drive-by rather than when he came back around. But one point that did remind me of on the concession is, they've conceded it was reasonable to remove him from the car. So they've conceded that the circumstances the officers were confronted with at that time satisfy the Graham factors. He was acting erratically, yelling, wouldn't communicate with them, was non-compliant, may have had a weapon. Those same facts and circumstances continued throughout the entire encounter. So to the extent that they've conceded that provides justification for that initial use of force, it's our position those same facts continue to provide the justification throughout. He was still erratic, non-compliant, unwilling to communicate, out of control, and potentially armed. And it was reasonable for them to use force to gain control over him so they could handcuff him and search him. Thank you.
Thank you. We have your argument. Mr. Roberts, I see you have 5 minutes.
May it please the court. I would like to direct the court first to page 767 of the record. I believe that is where we actually have in the record evidence that goes to show the intentional placement and knowledge that the glass was going to harm Mr. Priest where he was placed. In that is the deposition testimony of Officer Fenwick. Question, what I'm saying is you were aware at the time that you pinned Mr. Priest on the ground that it was covered in glass, correct? Answer, yes. Question, and you were aware at the time that you pinned Mr. Priest to the ground on that glass is dangerous, can cut and injure someone? Yes. Officer Fenwick also testified that they are trained not to injure suspects with broken glass, which is also one of the reasons they testified that they broke the back glass instead of the driver's window glass so that it didn't shatter onto Mr. Priest. They were aware that the glass could injure Mr. Priest if they still put him on top of that glass and pressed his face into it.
One of the officers was also injured in the glass too, right?
Yes, Your Honor. I believe, yes, Judge Oldham. I believe that, I'm not sure if it was Officer Fenwick or Officer Grazier, but one of them was also injured in the glass.
So if I'm watching the video and I see them trying to get Mr. Priest out of the car and he's clearly, I suppose you would agree with me, he gets his arm stuck in the seatbelt as he's coming out. I'm not sure what I'm supposed to do with the fact that he's clearly not put down where the officer was trying to put him down because they get hung up on their way out of the car, right? We credit the video over allegations to the contrary, I would assume.
Right. And it's obvious from the way he fell out of the car from the video that it may not be exactly where they were wanting to place him, but it is where they placed him. It is where his body landed. And simply the fact that his body was on top of the glass doesn't mean that they had to press his face into the glass. There's a difference between restraining him on the ground where the glass was in order to handcuff him and actually using Officer Fenwick's knee to press the face into the glass, causing the significant injuries to his face. So there, I think, is the difference between where he landed and the additional pushing his face into the glass. One thing I'd like to address here is opposing counsel stated that Priest has no version of event because he could not remember this. He didn't have an affidavit, and he doesn't have deposition testimony explaining his version or his memory of events. But that's just simply not the case that he doesn't have a version. His version is based off of the video and the deposition testimony. This would be like saying in a case where there was someone killed in a police shooting that because they don't have their version of events in the record, we have the body camera video, therefore there's no way of looking at what the decedent's version of events would be. So
Counsel, I was going to ask about that. I mean, but the point is, he has no recollection of any of the events independent of the other evidence in the record, correct?
Judge Wilson, yes, that is correct. Because of the distress he was in, he doesn't have a memory of what happened, and his version of events is simply based off of the video and the deposition testimony in the case.
So to the extent we have a fact issue that defeats summary judgment, it's going to be in the officer's testimony or via the video, correct?
That is correct, Your Honor, yes. It's also based off of the significant injuries that he had. Because injuries, the seriousness of injuries can be used to determine whether or not the use of force is excessive. And this is from the DeVille case. And the fact that his injuries were so significant, I believe the pictures are in the record. They're large gashes on his forehead from where his face was pushed into the glass and moved around with Officer Fenwick's knee. So it's not only that we have the video and we have the deposition testimony of both Officer Grazier and Officer Fenwick, but we also have the significant injuries that he sustained as a result of this use of force.
So if I understand the theory, you concede that it's okay to get him out of the car. It's obviously okay to break the glass in order to get him out of the car.
Yes, Judge Ruddle.
And it's okay to put him down on the ground because obviously the officers didn't intend to put him down exactly where he fell. So that's all fine. But the theory is that the Fourth Amendment required the officers to pick him up off of that piece of ground and move him to a non-glass covered piece of ground.
I believe, no, Your Honor, I believe what we're saying is that the Fourth Amendment requires the officers not to use an elevated level of force in response to what the need is. In this case, the need required them to restrain him, to handcuff him, but did not require them to force his face into the glass.
So I guess my question, let me put it this way. He's on the ground in the glass, right, and through no one's fault. I don't take it to be your argument that anyone intentionally put him into the glass. So through no one's fault, he's in the glass. But now the question is, split second, how do we get him out of the glass safely? And the theory must be that the officers can't do what they did, right? I understand your argument that they shouldn't have pushed him down into the glass, but that the Fourth Amendment affirmatively requires them to do something different to get him out of the glass without putting his face into the glass.
I think that the Fourth Amendment requires, and Your Honor, I do see that my time is about to be up. If I have any...
Go ahead.
Yes. I think that what the Fourth Amendment requires is that they not go further than restraining him and pushing his face into the glass. I think that it was unnecessary due to his level of noncompliance at the time. It was maybe not due to the act of resistance that is being alleged because of his medical distress, but it is because of the pushing the face into the glass that's where the Fourth Amendment was violated. Thank you very much.
Do you want an opportunity to respond to the two out-of-circuit cases that opposing counsel mentioned?
I would like to have an opportunity to respond to that, Your Honor. Thank you. Yes, opposing counsel cited two out-of-circuit cases. As she said that they are not binding on this court. I think one important factor about those cases is that the level of force that was used was substantially less elevated than what the force used in this case. It was much more measured to the response of what was going on in that case. The plaintiffs in those cases were fleeing or doing some other type of resistance, and then punches were used, tackles were used. There was not a forcing the face into glass or anything of that nature. And so I think that
So I take it you're saying those cases don't involve the pushing of the face in the glass. Got that. As to the three punches during this alleged pinning, or, the stipulated pinning, are those cases distinguishable, or are they similar?
I believe they are distinguishable, Your Honor, and I think that really the case that, if you're looking at the cases for the punching, it would be the Trammell case out of this circuit, would be much more instructive and controlling on the court than an out-of-circuit.
But how do the out-of-circuit cases, how are they distinguished?
Well, in those cases, there was actual active resistance, whereas in this case, there was just the pinning of his arm but underneath the ground, which I believe the court, it's 717 of the record, and I believe that Judge Ho, you found that when you were speaking just a little while ago. But his arm was actually pinned, and it was a physical incapability of removing his arm.
So you're premising it on the resistance point?
I'm sorry?
You're premising your theory of distinguishing those cases is the lack of resistance in this case?
Yes, Your Honor.
Any other bases, or is that the basis?
No, I think that those are, the main similarities in those cases is the fact that there was a plaintiff that was having a medical distress episode, but I think that the facts are distinguishable due to the level of resistance.
Okay.
And if there are no other questions, thank you very much for your time.
Thank you. Your case is submitted. Again, would like to thank counsel on both sides for their interest and willingness to appear before us in person today. And with that, we're adjourned.